everybody, welcome to my channel, and what we're going to talk about today is probably some of the most egregious forms of corruption that exist in government. It's beyond belief. All of this stuff that I'm going to tell you today is all in the public domain. It's all been filed. I'm not going to be presenting anything, even though I do have other information to substantiate my this video, the claims I'm going to make in this video. I'm only going to discuss what has been made public so far, what anyone through a public an open records request, or if you've got a Pacer account or a FOIA, would be able to help you find. So yeah, let's just get to the meat of it. I just found out this week that I have been charged with a Class A misdemeanor of hindering a proceeding by disorderly conduct. That is a Class A misdemeanor. Not only was I charged, but my client, Jason Followell, was charged, and they were charged by the exact, we were charged by the exact same person we just filed a complaint against. And so I'm going to start backwards and kind of show you everything that's been going on. But on, no, I don't have any updates on Jack Miller. I do know the charges against Jack. That's not what this video is about. I might do a separate one, but we're still collecting all the evidence. But this is just more ongoing tyranny, because in the Jack Miller case, it's the exact same thing. He's going through the same retaliation that we are. We just sued that police chief for doing exactly what she just did, which is unequal application of the law. And apparently it's okay to run over a guy with a skid steer tractor, and that guy can't use pepper spray to defend himself. And then instead of just arresting him, they do this giant raid on his house with like 5 or 6 police cars, and they rope off the entire block. It's just nonsense. Texas is out of control. Texas law enforcement are out of control. If you are a First or Second Amendment activist, I want to tell you something. Watch your back. Watch your back, because the government is going to come after you. If you try to hold them accountable for holding them accountable, they're going to come after you. Okay. And that's what really this video is all about. Although it's obviously a little bit more personal. I have hired an attorney. His name is, so there's a case against me. It's the state of Texas versus Christopher John Grisham. That is me. I've hired an attorney. His name is CJ And so CJ Grisham is going to be defending Christopher John Grisham against these bogus charges. And the law offices of CJ Grisham has graciously offered to take this case. And so I appreciate it. So thank myself very much. So here's the deal. And I'm gonna kind of show you a little bit of the history here. This is the complaint that is filed. It's filed in the Southern District of Texas. This says Waco Division. I've fixed that. It's actually the Corpus Christi Division. So this is wrong, but that was corrected. So don't worry about that. But it is the Southern District of Texas. You know, I used templates, and I forgot to change when I filed a case in the Western District. I just forgot to change that part, even though I changed the Western to Southern up there. I forgot to do that. Anyway, so this is the complaint. I'm not really going to go through it all, really. But as you can see, one of the defendants here is Chief Blanchard, the chief of police of Aransas Pass. And he's a main instigator of a lot of what this lawsuit was about. You got a warrantless search that we're alleging, cease and desist letters to prevent citizens from speaking up. The July 5th Aransas Pass meeting. Then I talk about the unconstitutional criminal trespass that the city did against my client that I had to get lifted. They tried to tell me that he was trespassed from all property for no reason whatsoever. I mean, they made up a fake reason, but obviously once I got involved, they realized, oh crap, we better do this legally. Oh wait, we can't do it legally. So of course we talk about that. the December 4th Aransas Pass city council meeting where Mr. Followell called the fire chief a fucking moron, which is protected. The mayor says, if you continue cussing, you're going to be escorted out of here. Sorry, cussing's protected speech. It's just that simple. The mayor says, I'm not going to put up with your foul mouth. He says, I'm not going to put up with any of that. Ain't nobody need to be cussing anybody out. That's ridiculous behavior. But it's protected behavior. Sorry. I mean, we could argue all day long whether or not it's civil. That's not the issue. When you're going to use the power of government, you have to do what's legal, not civil. Then you've got the January 16th meeting, which is the one that kind of went viral, where he and I were both there. He made his comment. I think he called someone a piece of shit or something like that. I can't remember if I put it in there, but I just put that he used profanity in his speech. And so then, we're making a First Amendment claim relief. We're doing a Fourth Amendment claim relief. We're doing a 14th Amendment claim relief. We're doing a retaliation claim relief, a defamation claim relief, municipal liability. All right. So that's what happened. That's that's what really kicked all of this off. So there was a meeting on January 16th in December. I believe it was December, late December or early January. I had sent the Aransas Pass City Council essentially a demand letter. Look, you violated my client's rights, and I demand that you stop it. And if you're willing to reimburse my client for violating his rights, he won't sue, kind of thing. And so after January 16th and what they did on the 16th, I sent a follow-up email because I'd given them 30 days to either come to the table and mediate this and figure out something, or we're going to sue. And on the 18th of January, I rescinded that, and I made very clear, I sent them a letter informing them that never mind, my offer is off the table, and we're going to be suing you, and so you need to protect all the evidence in this case. You need to protect emails. You need to protect your ESI, which is electronically stored information, phone calls, documents, everything. Don't delete anything. Inform your IT department not to delete anything because we're coming after you. That's what I said on January 18th. I filed the case formally on March 1st. As you can see, let me go back up to this. As you can see here, the case was filed on March 1st. Okay. That's when I filed the case against Chief Blanchard, the mayor, the fire chief, etc. Again, this is all public knowledge. You can go and look at it on Pacer by pulling up the case number, which is 2:24-CV-00055. And so I filed that on March 1st. On March 4th, I had them served. You might recall that video as well, and where I had them served during the city council meeting. So on March 4th, I had them served. Well, here's what came up on March 14th. Make this a little bit bigger here. In connection with a complaint of David Wood, a competent and credible person. Who is this David Wood? This David Wood is a former police chief of Aransas Pass. He was also, when Jason Followell had a protest near his business, David Wood was one of the snipers on the building. So that's who he is. But Christopher John Grisham, the defendant, did then and there on January 16th intentionally hinder an official proceeding, namely a City of Aransas Pass council meeting, by violent or tumultuous behavior or disturbance, and that the defendant was yelling aggressively and physically pounding on the podium with his fist while using foul, vulgar language. Now, I want to put something here. First of all, I'm going to come back to the yelling aggressively. This right here. I'm going to play you what happened that day. Okay. And I don't know, hopefully you'll be able to hear this. If you can't hear this, let me know. And I'm going to pause the video as soon as there is a pounding of fists, because otherwise that's what's called falsifying an official government document. It's also called malicious prosecution. It's also called defamation. There's a lot of things that you can call that in the civil world.
Mr. Mayor, City Council, my name is CJGrisham. I'm a civil rights attorney here in Texas, and what I just witnessed was a violation of Mr. Followell's rights. Let me read something to you. Arresting someone in retaliation for the exercise of free speech rights is sufficient to chill speech as an understatement. This is Beck v. City of Upland.
And look, there goes the chief. Chief Blanchard knows what's coming. He's like, oh man, this is awesome. I might get to arrest CJ now. By golly, I'm gonna get behind him because I'm a coward and I'm a thug and I'm weak. And the only way I know that my blubber can go after CJ is if I take him from behind, if I sneak up on him, because that's the kind of guy that I am. That's kind of the authoritarian, corrupt official that I am as a police chief. Oh, CJ's speaking. I'm going to get up behind him and I'm going to sneak up, and that way he can't react to me.
Arguing, even if done loudly, with a profane or offensive language will not, in and of itself, constitute disorderly conduct. That's Payne v. Pauley. Swear words do not provide probable cause for an arrest for disorderly conduct because the words, as a matter of law, are not fighting words. Johnson v. Campbell. I could go on, Mr. Mayor. Your rules of decorum are unconstitutional, and they're setting the city up, you individually, for liability. Now, you will be seeing a letter from me, a demand letter for violating my client's rights just now, because he has the right to say fuck, shit, damn, bitch, cunt, whatever. He has the right to say all of those words because it is a First Amendment right. You can't do anything about it. Let me tell you something. The law has long established that arresting an individual for...
Now let me ask you this. Am I, what was the word? Hang on, let me pull this up again. What was the word used? It was yelling aggressively. The defendant was yelling aggressively. Does that sound like I'm yelling aggressively? Just wondering. I mean, even under a normal interpretation of yelling, in any way, is that yelling? No. Okay. I didn't think so. And we're still looking for the pounding of the fists. Okay. Remember, this is written in the official information. This is written in the official complaint that I, Christopher John Grisham, at this moment that you're looking at right now, was yelling aggressively and pounding my fist on the podium.
Violates the First Amendment. That's the Cohen case, 1969. Indeed, the Supreme Court recently held that a public school violated the free speech rights of a cheerleader by suspending her when she said things like fuck school, fuck softball, fuck cheer, fuck everything. So I could say fuck throughout my entire free.
Sorry about that. I forgot to turn my mute off. Because the train was going by. Sorry about that. But I was literally just quoting case law, and the mayor starts interrupting me during my 3 minutes, saying, "Oh, here we go." And yeah, so they're already coming after me because I'm literally quoting words out of a case. which was a case in which someone had told a police officer, police chief, to F you, right? A direct quote.
Fuck again, and I can say fuck again, and there's nothing you can do about it because it's called expressive speech. Think about you. If I think you, Mr. Mayor, are a tyrant, I can say that. If I think the city manager is a piece of shit, I can say that. It's protected. This is the case law. I don't give a shit what you think.
Now, here's the part where I do start raising my voice, because now the city mayor is over there yelling at me. Let me back this up a little bit because the train was going by. So the city mayor starts, while I'm speaking during my 3 minutes of public comments, he starts trying to speak over me. Now, keep in mind, there's a microphone in front of his desk and there's a microphone in front of mine. So in order for me to get my 3 minutes across, I have to raise my voice.
City manager is a piece of shit. I can say that. It's protected. This is the case law. I don't give a shit what you think. The law is like, you escort me out, I'll sue you as well, Mr. Mayor. Do whatever you want. This is the law right here. And if these chiefs come out here and pull me out of this meeting, you had better read this, chief, because he's telling you to break the law.
Keep in mind, this is still during my 3 minutes. I'm not hindering anything. And I'm going to go over the elements of hindering a proceeding by disorderly conduct. I'm not hindering anything. This is my 3 minutes of public comments. Now, if my 3 minutes were up and I'm still screaming and yelling, then yes, that could potentially be hindering. Now, I'll tell you why it's not, but it's not. But this is still during my 3 minutes. I'm not keeping them from discussing issues. I'm not prolonging the meeting. I'm not keeping someone else from speaking. I'm not doing anything other than speaking during my 3 minutes.
Yeah. You can take him out. Now, where did that coward Kerry Scruggs go? You go out. Where did the coward Kerry Scruggs go? Take him out. Is my 3 minutes up? No. Is my, what am I gone for? What am I gone for? No. He pulled you to violate the law. Oh, you're going to arrest me?
So he just said he was gonna send me to jail for, quote, disorderly conduct. Disorderly conduct. That's what he said. He's going to send me to jail for disorderly conduct. And at that point, I'm like, okay. So again, now keep in mind, the timer still hasn't gone off on my 3 minutes. The timer still has not gone off. I've been interrupted. They've taken part of my 3 minutes, but the timer still hasn't gone off. This is still my time.
Oh, you're going to arrest me? Okay, so under the threat of arrest, you just violated my right.
All right. So there you go. That's the video. Now, let me ask you a question. Everyone out there. At any point, let me bring this back up. At any point, did you see this? At any point, did you see Christopher John Grisham, i.e. me, that's what the CJ stands for, by the way. I guess the secret's out now. Physically pound on the podium with his fist. But you know what? This is a government document that's been signed by a county attorney. Been signed by a county attorney, Tamara Cochran. As if this were fact. Pounding on the podium with my fist while using foul and vulgar language. Was there foul and vulgar language? Yes, absolutely. There was foul and vulgar language. Foul and vulgar language is protected speech. Now we go down to the affidavit. This is the affidavit filed by none other than Chief Blanchard, the very man that on March 4th, I served with a lawsuit that I filed in federal court on March 1st. And according to Eric Blanchard, what I did was intentionally hinder an official proceeding. Again, there was no hindrance. It was my 3 minutes. I didn't hinder anything. The meeting went on. When I was done, the meeting went on just as scheduled. The next person with 3 minutes got up there. The next person with 3 minutes got up there. It was not hindered. Says that I was yelling aggressively while using foul, obscene, and vulgar obscene. Right here. What is obscene, ladies and gentlemen? Do you know what obscene is? I'm gonna show you. This is the motion to dismiss that I filed in this case. As soon as I found out what the case number was, I drafted up my motion to dismiss because I have cases to deal with. I don't have time to deal with retaliation by washed up, corrupt, authoritarian, tyrannical police chiefs in South Texas. I've got real things to worry about here. Okay. I don't have time for temper tantrums by people with a badge. I just don't. I've got other innocent people to defend. Now I've got to defend this innocent person. But I'm gonna show you something here. Obscenity. Obscenity is not protected speech. This is the words of the courts. This is how obscenity is defined. Obscenity in Texas is defined as material or performance that the average person applying contemporary community standards would find that, taken as a whole, appeals to the prurient interest in sex. Nothing I said at that meeting can in any way, even if you're a complete moron like Chief Blanchard, be considered obscenity. There is a difference between obscenity, profanity, and vulgarity. Now, Chief Blanchard, who's been wrong at every step of the way, believes that profanity and vulgarity equals obscenity. Nope, I'm sorry. They do not. What is not protected? Incitement, obscenity, which I just defined, defamation, fighting words, child pornography, and speech that's integral to criminal conduct, like true threats. That's what's not protected. But you know what is protected? This is protected speech. And here's the proof down here in my notes. That is protected speech. This is protected speech. How do I know? Because footnote 18, here's the case law on it. Guy had a sign that said shit is fucked up and stuff. Nope, that's protected. A defendant who called his accusers, quote, chicken shit, protected. Protected speech. How do you know? Holding that right here, Lewis v. New Orleans, this is a Supreme Court case, 1974, holding that UGDMF police is protected speech. That word right there, protected speech. How do I know? Footnote 20, Fifth Circuit case. Again, protected speech. Lastly, the one that Kerry Scruggs really hated, protected speech. So, in this instance, now in this case, this is what's interesting about this case. In this case, a professor was fired from a public university for using these words. But what the court found was that they're protected if they are germane to the subject matter. But like if you're just calling your students these words, that's something else. Now, in this case, I am saying that profanity is protected, and I'm talking about case law. So my use of these words was germane to the subject matter of free speech in this case. All right. So I've shown you that it's not obscene. Foul language is protected language. Vulgar language is protected language. Now, if I'm yelling aggressively, guess who else is yelling aggressively? The city mayor. The mayor is yelling aggressively. So if I'm yelling aggressively, the city mayor is yelling aggressively. Where are his charges for impeding or intentionally hindering an official proceeding? This was signed, by the way, on the 13th of March. 13th of March, ladies and gentlemen. What is that? That is 9 days after I served Chief Blanchard with his federal lawsuit for this exact issue. This exact issue. I served him because I was arrested, or not arrested, threatened with arrest. And then 10 days later, it's like, oh, wait a minute, crap. I need to cover my ass. And, if I'm going to cover my... Look, this happened, ladies and gentlemen, on January 16th. He had 2 months to file charges. 2 months to file charges against me. And he waited until March 13th to do so. 9 days after I filed my federal lawsuit on behalf of Jason Followell against him. 13th of March, 9 days. And then this is just the official summons. But here's the police report. Chief Blanchard. Chief Blanchard. That's the guy. By the way, they got my social security number wrong on the complaint, so I don't care that you guys saw that because it was wrong anyway. So now guess what's going to happen? So here's my motion to dismiss. Now, I'm obviously challenging the complaint on two different angles. The first is what's called the Texas Citizens Participation Act. And the second is, of course, the First Amendment and our state constitution as well. My court date is on May 29th, 2024 in San Patricio County if this does not get dismissed. If it doesn't get dismissed, likely May 29th will be my motions hearing instead of my first appearance because I've already filed my motion of appearance or notice of appearance, excuse me. But in arguing that this violates the TCPA, and this is kind of a weak argument because the TCPA generally has been used in civil cases, and the TCPA is Chapter 27 of the Texas Civil Remedies or Civil Practice and Remedies Code. So it's in the civil world generally. But as I argue here, Texas Citizens Participation Act protects the alleged conduct, city council meeting. So this was passed by an act of the legislature incorporated into Chapter 27 to, quote, to encourage public participation by citizens by protecting a person's right to petition, right of free speech, and right of association from meritless lawsuits arising from actions taken in furtherance of those rights. And that comes straight out of HB 2973 during the 82nd legislature in 2011. The act defines a legal action as a lawsuit, cause of action, petition, complaint, cross-claim or counterclaim, or any other judicial pleading or filing that requests legal, declaratory, or regulatory relief. A criminal complaint is what charges are. This is an other judicial proceeding, and it's requesting legal relief. It's requesting that they send me to jail and convict me of using protected speech. I argue, even though it's under the Texas Citizen, even though it's under the Civil Remedies and Practices Code, Civil Practices and Remedies Code, I always get that backwards. It's still a legal action, and this still covers it. And of course, it's based on my right of free speech. I have a right to file this action, to have this dismissed. 27001, subparagraph 6. And, oh, I'm sorry, actually, that might be, 27003. That's the definition paragraph right there. 27001, that's the definition paragraph. But this is that allows me to file a motion to dismiss. Now, while I make this argument on the TCPA, I'm also making my First Amendment argument here because they really go hand in hand. In order to have a TCPA dismissal, you have to show that the conduct that you're engaging in is protected speech. And so they kind of go hand in hand, but I really, there's a reason I'm going into the TCPA, and I'll show you that a little bit later. And this is important because here's what the TCPA really does. Let's say you go to Aransas Pass and you call the mayor a tyrant, right? And or you accuse the city councilwoman of falsifying a death certificate or something like that. And then she sues you, or he sues you for defamation, for calling you a tyrant. Well, you file a motion to dismiss because you're allowed to call the mayor a tyrant. And that's your right. You've got the free speech to do so. So you file a motion to dismiss that civil lawsuit, right? This has been happening in Killeen, Texas, where the corrupt mayor has been suing people who have been criticizing her corrupt government and the way she's doing this. And so that's the TCPA is designed to prevent the government from wielding the power of government to prevent you from speaking and seeking redress, which are the two things I was doing that day. So I'm the attorney of record for an ongoing civil lawsuit against the city, against Ram Gomez, against Chief Blanchard. This is why this is important, because it was Chief Blanchard that filed this. Now, what I found interesting here is that David Wood wasn't even there that day. So here's what I think happened. This is just my opinion. Just my opinion. I literally have, because if I had background information on this, I wouldn't be discussing it, because I am not going to discuss anything that's not public. Or that can't be obtained through public information. He wasn't there on January 16th, this guy. So what I think happened was Chief Blanchard probably said something like, hey, David, my boy, retired Aransas Pass police chief, I need you to file this complaint, because if I do it, it's going to be obvious that I'm retaliating against him. I don't want it to be I don't want it to be obvious, okay? I don't want it to be obvious. As a matter of fact, I would argue David Wood doesn't have any standing here. The only people that have the standing are the people that are running the meeting. That'd be my argument anyway. But then, of course, later, you know, you've got Eric Blanchard that decides he's going to speak up. Now, I don't know what this is. I don't know who's signing this. But it says here that I, the undersigned affiant, informed by this person. So, which happens to be the same person I'm suing. So I explain exactly what you just watched on January 16th. I saw my client's rights be violated. This was during citizen comments. The purpose of citizen comments is for matters that are not scheduled on the agenda. Citizens are asked to limit comments to 3 minutes. Citizen comments is a broad designation for an open session of unsolicited citizen comments and questions. That's what this is. Where does that come from? This case law right here. Hayes County Water Planning Partnership versus Hayes County. It's 41 Southwest 3rd, 174, page 180. That case. And what they're doing here, what this case does, is it quotes the Texas Attorney General Opinion 0169. So the Attorney General has said this. The appellate courts have said this. That's what citizen comments is for. The city says that it's for matters that are not scheduled on the agenda. Obviously, they are not going to schedule the chief's corruption and the mayor's corruption to talk about as an agenda item, because they don't want to. They want it to hide. They don't like the fact that Jason is up there holding them accountable for $1,200 suits for private purchase. Now, government bodies are allowed to adopt reasonable rules consistent with relevant provisions of law. In other words, you can have rules, and generally what these rules are, if you look at, I mean, I'm under number 7, I've got several attorney general opinions here. Generally what it's talking about are like time issues, right? When is too much, when is too little, et cetera, et cetera. But still, I think they could even have consistent, not using obscenity, of course, not using hate speech, of course. But it's got to be consistent with law. And when the First Amendment protects your speech, your right to criticize the government, even when those words hurt you, that's not consistent with relevant provisions of law. Speech on matters of public concern is at the heart of First Amendment's protection. And I'm going to give you guys all this case law too, because it's important. That's Dun & Bradstreet Inc. v. Green Moss Builders. Here's the case for it. And it's quoting another case here. These are Supreme Court cases. The matter of public concern on January 16th, when Jason and I were speaking, was whether city managers' rules of decorum violated the First Amendment to the Constitution of the United States. That's what I don't know why I put that there. I find these I find these little itty bitty intricacies when I'm reading these. It's funny because I reread these several times before I file them, hoping that I catch everything, and I'll make several corrections. But apparently, I missed this one. I don't know why this closed parentheses is here. But anyway, so this was the matter of public concern. But there was also the matter of public concern that the chief of police charged taxpayers over $1,200 for a personally fitted suit. That's a matter of public concern. That is a matter of public concern. And these rules of decorum cannot violate relevant provisions of law. They cannot violate the First Amendment. You can't have a rule of decorum that says you cannot criticize us. You cannot have a rule of decorum that says you can't speak to us unless you're dressed in a shirt and tie and loafers and a Sunday dress. You can't speak to us unless you say good things about us. You can't speak to us unless you praise us for everything that we're doing. Those rules of decorum are called unconstitutional for a reason. They have to be consistent with relevant provisions of law. The Supreme Court has defined a matter of public concern as something that can be fairly considered as related to any matter of public or political, social, or other concern to the community. Do you think the community should be concerned about the fact that the chief of police is charging taxpayers $1,200 for a personally fitted suit? You know, there are attorneys that don't have $1,200 suits. That's a matter of public concern to the community. Do you think that there's a political and social matter of concern regarding the First Amendment to the Constitution of the United States? I think so. That is a matter of public concern. The Supreme Court has said so. Where? Snyder v. Phelps, Connick v. Myers. The speaker's position also plays a role in this determination. In other words, me. If the speech is made primarily as a citizen rather than as a public employee addressing matters only of personal concern, it is more likely to be considered a matter of public concern. What was I doing? I was not a public employee. I'm a citizen. I'm addressing a matter of personal concern, which is violations of the First Amendment. And the fact that my client has a right to speak up about $1,200 suits being charged to taxpayers by the police chief. I was protecting my client. That's Patel v. Trevino. You can go look that one up. Now, that one's not a published case. That's what this means. It means it's not a published case, but that's what the court found. It's just not published, but it's still an appellate case. So while I was addressing city council, I quoted actual case law regarding the use of profanity in public and criticism against public officials. The First Amendment provides, naturally, no law abridging the freedom of speech. And as a general matter, the First Amendment means the government has no power to restrict expression because of its message, its ideas, its subject matter, or its content. And if it does, it falls under strict scrutiny. There must be a compelling government reason to restrict speech. That's the whole reason why, as Chief Blanchard told you yesterday on his live on Facebook, if you didn't see it under the City of Aransas Pass, he did a little Facebook Live thing, and he even mentioned if you tell a lie enough times, people will start believing it. And so that's what he did for the rest of his live stream there, was tell a lie a bunch of times, one of which was you can't, well, this isn't a lie, but that you can't yell fire in a crowded theater. Why? Because it's obviously a compelling government interest that people not be trampled based on a false statement. Now, this broad pronouncement is subject to certain exceptions, such as, and we already went over this, incitement, obscenity, defamation, fighting words, child pornography, all that stuff, right? I already went over this. He tried to say that what I said was obscene. It was not. I didn't incite anybody. I didn't defame anybody. I used my personal actually, I didn't even say anything. I said if I wanted to call you, Mr. Mayor, a tyrant, I can do it. If I wanted to call the chief of police or the city manager a piece of shit, I can do it. I didn't call anybody anything. I said if I were to do that, I could do that. That's not defamation. I didn't say he is, but even that would be an opinion, because it's pretty obvious that he's not excrement sitting in a chair. Now, I guess that's probably up for debate. There's obviously nothing there about child pornography. Definitely not fighting words. Definitely not true threats or encouraging people to engage in criminal conduct. And I already went over the obscenity issue here. So then I talk about what did I say? And I've already played that for you. At one point during my public comments, I stated, my client has the right to say these words. And that's what he did. My client has a right to say these words. That's what I did. I quoted case law. And, later, as I mentioned earlier, each of those words are protected. After explaining the case law, I told the council that if I think you, Mr. Mayor, are a tyrant, I can say that. If I think that the city manager's a piece of shit, I can say that. And again, I'm talking about my client's personal opinion or any citizen's personal opinion about a public official. But as soon as that statement was made, Mayor Ram Gomez ordered me out of the meeting during my 3 minutes of speech discussing matters of public concern, and I even provided them a written copy of the cases. Now, initially, they refused to accept that from me. But at the end of the meeting, I walked up to Chief Blanchard, who, remember, is the complainant here, and I gave him a copy of the case law. I provided him with a written copy of that case. I already went through all this stuff. The law is long established that arresting an individual for public vulgarities violates the First Amendment. This is Knowles v. Dial, holding that officers did not have probable cause to... Wait, that's not that one. Oh, there we go. Yeah, 22. Cohen v. California. I was going to say, I know these cases. I'm like, that's not what that case says. The defendant was literally quoting case law on a matter that just occurred in his presence. Defendant was engaged in protected speech to protect the speech of his client, using examples of the court declaring such speech protected. At no time did defendant engage in fighting words, nor did he direct his speech directly at any individual, i.e. they were not fighting words. His words were couched in a hypothetical. If a citizen said the particular words, those words would be protected. That's all I'm doing. Education. Apparently they don't want to be. Apparently educating the city council is now a crime. The purpose of his speech was to educate the council on the rights of his clients and encourage him to cease violating them. Then I talk about the fact that I filed a case against them and that this is purely retaliation. That's really what all this is about. That's what this section's about. That's why they're filing these charges. Then I talk about my First Amendment. The First Amendment prohibits the government from limiting the stock of information from which members of the public may draw. I don't know why it's not. Oh, well, it's not getting that. And then arresting someone in retaliation for their exercise of free speech is sufficient to chill speech is an understatement. And that comes from Beck v. City of Upland. I quoted that during my speech, but there's the citation if you want to write that down right here at the bottom. I don't know why it's not highlighting anymore. Additionally, swear words do not provide probable cause for an arrest for disorderly conduct. Remember, the chief said that he was going to arrest me for disorderly conduct. Remember that? He said it. And he's using it right here. Vulgar language, swear words. But that does not provide probable cause for an arrest of disorderly conduct because the words, as a matter of law, are not fighting words. That is Johnson v. Campbell. Now, it's a Third Circuit case, but still relevant. Speech on matters of public concern is the essence of self-government. Snyder v. Phelps, quoting Garrison v. Louisiana, Supreme Court case. Accordingly, speech on public issues occupies the highest rung of the hierarchy of First Amendment values and is entitled to special protection. I should say is. So you can tell I don't copy and paste stuff. I actually type everything out. And sometimes I type so fast I might type a word wrong. So it should say it is entitled to special protection. But you get the idea, because if you go and look at Snyder v. Phelps, you will see the real quote that quotes Connick v. Myers that says that. And then, of course, I've got my conclusion. So I say, because of the First Amendment and because of the Texas Citizens Participation Act, even if they say, look, you can't say the Texas Citizens Participation Act, that's a civil case, or that's a civil remedy, that's not a criminal remedy. There is some case law out there, by the way, that I was made aware of after I filed this, that leaves it open. It isn't very specific. And then, of course, the prayer for relief. So that's what's been filed. That's everything. I know the chief is out there trying to lie about stuff. It's important that you know and see everything for yourself. You know, the chief says if you tell a lie enough, eventually people will start believing it. That's what he wants you to do. I wanted to show you exactly what his words were. I wanted to show you exactly what my words were. And I wanted to show you exactly what the law states, which, yes, right there. That's the chief. Wow. And by the way, ladies and gentlemen, let me show you this real quick. This right here is the chief after he says he's lost weight. I'm just going to leave it at that. I'm just going to leave it at that. This is the chief after he said he lost weight. Okay. So we need to, congratulations, chief, on losing weight. Good job. All right. If we go to the penal code, this is the last thing I'm going to talk about, and then I am going to go home.
On that note, I'm going home.
Okay. Love you, babe.
Hi, everybody.
That's my wife back there. Oh, wait. No, sorry. I'm on the wrong. It's 38. Not 28. Hindering government proceedings by disorderly conduct. Oh, please shut it in case another train comes by. Okay. Thank you. All right, ladies and gentlemen, this is the law. This is what I'm charged under. It is a Class A misdemeanor, which means that there is a fine of up to, I think, $5,000 and 1 year in jail, ladies and gentlemen. 1 year in jail for using profanity. Although that's not really what this is about. A person commits an offense if he intentionally hinders an official proceeding. Hinders. Big word there. At any point, if you go and look at on YouTube, you can go and watch for yourself. If you type in City of Aransas Pass and you go to the January 16th, 2024 open meeting there, and let me know if at any point the meeting was hindered. As soon as I left, guess what happened? The very next person walked up to the podium. And then the very next person walked up to the podium. Nothing was hindered by noise or violent or tumultuous behavior or disturbance. At no point was anything hindered. None. And here's the thing. Here's the thing, right? If you make a noise, but it doesn't hinder, okay? If you are violent, but it doesn't hinder. If you are tumultuous, but it doesn't hinder, you have not committed a crime. Oh, and by the way, you have to intentionally do that. Now, in this case, I'm not making a noise for the purpose of hindering the proceeding. I'm making a noise because I'm being falsely arrested. Well, threatened with arrest. It's the same thing. When you're threatened with arrest and you do something because of that threat of arrest, you might as well be arrested. It's the same thing. A person commits an offense if he recklessly hinders an official proceeding by noise or violent or tumultuous behavior or disturbance, or continues after explicit official request to desist. Again, I wasn't hindering anything. It was my time. He asked me to stop with my noise and violence, but I wasn't hindering anything. It was my time. If anything, I was hindering my message. That's the problem with this charge. In order to hinder, I have to have stopped their governmental official proceeding. I had the time. The time was mine. That's it. Nothing was hindered. When Mr. Followell was up there speaking, nothing was hindered. And by the way, the chief charged Mr. Followell with this exact same charge. He and I are both faced with the same charge. And as soon as I am made aware of his case, I will be filing into that. Yes, he has hired me for his case as well. And I will be filing the motion to dismiss. And I'm also going to be filing, based on whether or not it gets dismissed, my federal lawsuit and joining the criminal action until the civil rights aspect of free speech is determined. That I had a right and that my rights were violated by threatening to arrest me and by retaliating against me and by maliciously prosecuting me by pressing these charges. So hopefully it's just going to get dismissed. Honestly, I'm going to be open with you, and I'm not going to say who or what or when or where. We've got good prosecutors, some good prosecutors in this county, and I trust them that they're going to do the right thing, whatever that is. Okay, they're going to do the right thing, I believe, in this case, and justice will be served. But this is just one more example of out of control policing in the state of Texas. And here's the thing: if the court denies my dismissal based on the TCPA, I understand that there's an argument, I think, on both sides. As a matter of fact, I've already sort of after the fact looked into this, and I've already written some things down. So, where did I write that? Come on. All right. So there is an unpublished opinion out of, there's just one unpublished opinion that addresses this particular issue that I'm doing. And it's, you know what, here, I'm going to pull this up, but it's in the Fifth Circuit. It's called Macomb v. State. The case number is 5-22-00385-CR. I'm going to put that in the comments. Actually, I'm going to write this whole thing down here. So if anybody wants to look this up. And that's not in this district, so we can still make case law here. So there's the case. I just put it in the chat on YouTube if you're watching on YouTube. Oh, wait, what's going on here? Why did that? It said it's not working. Try it again. There we go. All right, it went that time. So anyway, there is a case out of the Fifth Circuit out of Dallas. It's the state Fifth Circuit, not the federal Fifth Circuit, out of Dallas. And then there's they've previously said there's a Florence v. State case. If you want to kind of reach out even further, not specific to the Texas Citizens Participation Act. There's Florence v. State. It's another unpublished out of Dallas opinion. It says we've previously stated civil laws do not apply to a criminal proceeding. Without identifying the civil laws, and in this case, they stated that without identifying the civil laws, he cited and he relied upon in that appeal. The civil laws cited by appellant do not apply in this criminal proceeding. But I think it was specifically that proceeding and specifically that particular law. I think in my case, as I laid out, it does apply because it talks about any complaint and any judicial proceeding. And so, I'm sorry, no. I even wrote later. We reached the same conclusion with respect to TCPA section 27.008 that as a civil law simply does not apply to a criminal proceeding. So it's possible that the TCPA, that this court may look at the Fifth Court of Appeals out of Dallas and find that, okay, well, I'm going to hold how they did. But I think I made a decent argument showing the exact opposite, because this was saying with respect to 27.008, right? And if we go back, and I'm going to bring this up, let me show you this here. Here is the TCPA. 27, there we go. Under the definitions of legal action, legal action means these things. And this is what I quoted in my case. It means complaint or any other judicial proceeding. It doesn't say civil judicial proceeding. It doesn't say civil lawsuit, civil cause of action, civil petition. Now, keep in mind, this is 27001, and the Florence v. State case was specifically talking about 27.008. Here's 27.008. If a court, and this is talking about the appeal. If a court does not rule on a motion to dismiss under 27.003 in the time prescribed by 00, the motion is considered to have been denied. So this is specifically talking about an appeal. And, you know, again, it's wordplay. That's what attorneys do. You know, we try to take laws, all attorneys on both sides of a case, try to take laws and get them to apply to our legal theory. My legal theory is that filing a criminal action against me is a complaint. That's what it is. It's called a complaint. Matter of fact, I think it even says so on here. Grisham complaint. Well, that's my summons. But that's what these are called. These are called complaints. Okay. Complaints / information. And there should be somewhere. Here it is, right here. Complaint. So this is a complaint. It's also a judicial pleading or filing, and it's requesting legal relief. That is, throw CJ in jail. I'm sorry, throw Christopher John Grisham in jail because he hurt my feelings. Matter of concern. Official proceeding. And here's what the law is. If a legal action, remember, what is legal action? It's a complaint. If a legal action is based on or is in response to a party's exercise of the right of free speech, the right to petition, or the right of association, or arises from any act of that party in furtherance of the party's communication or conduct described in 27010, what is that? Exemptions. Where'd I go? Hang on, I'm going to get to that in a second. Where am I at? Blah, 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 blah. If a or in furtherance of a party's communication or conduct described in 27010, that party may file a motion to dismiss the legal action. A party under this section does not include a government entity, agency, or an official or employee acting on official capacity. Motion to dismiss legal action under this section must be filed not later than the 60th day. I did that. Unless they mutually agree, blah, 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 blah. Now, here's where there's, so 27010B, notwithstanding section, this chapter applies to a legal action against a person, okay, arising out of any act that person related to gathering, receiving, posting, processing information for communication to the public, whether or not that information is actually communicated to the public. Anyway, it's the same type of thing here. It applies to what I was doing. Now, up here, it says 2, 7, and 12. So it doesn't apply to this, which is selling or leasing stuff. It does not apply to a legal action brought under the Business and Commerce Code. And it doesn't apply to a legal action on the common law fraud claim. So, notwithstanding those subsections, this chapter applies to a legal action against a person arising from any act of that person, whether public or private, relating to the gathering, receiving, posting, or processing of information for communication to the public, whether or not the information is actually communicated to the public, which I did, I communicated to the public, for the creation, dissemination, exhibition, or advertisement of a similar promotion or, oh, so this is just talking about dramatic, whatever's. A legal action against the person related to the communication, gathering, reviews of a business, and applies to a legal action against a victim or alleged victim of family violence, et cetera, et cetera. Now, what this does say here, this is where it kind of gets different. And this is why I included the First Amendment. It says this chapter does not apply to an enforcement action that is brought in the name of the state or political subdivision of the state by the Attorney General, District Attorney, Criminal District Attorney, or County Attorney. A legal action brought against the person primarily. Okay, and then these other things. So this is where kind of the problem is. It's like I said, if they deny my motion, I think if I'm going to lose, this is where I'm going to lose. I still think there's an argument based on the facts of this case being false, right? I'm not being charged. Well, I guess I'm being charged with the stuff that they claimed, of course, that I didn't do. And the stuff that I did do is protected speech. So anyway, it's just a legal argument. And I am not so haughty and high and mighty to say that I will win both of these legal arguments. I'm probably going to lose on the TCPA. Probably. If I knew I was going to lose, I wouldn't file under the TCPA. I just think in this particular case, as applied to me, that the TCPA would likely apply. And the only thing we can do is litigate it to find out. But if the reason I added in the First Amendment claim in here, the alleged conduct was protected speech, and in my conclusion, that I brought up the TCPA, that I was engaged in First Amendment protected speech at all times during allegations alleged in the complaint and should be dismissed. So even if I lose on the TCPA complaint, I should win on the First Amendment complaint. The case law on that particular aspect is incredibly clear. In fact, the very case law that I'm being charged under has been ruled unconstitutionally as applied to cases similar to mine. And those, of course, are in here as well. So if we end up going, I can also file a motion to dismiss because the law as applied to me, I can do an as applied challenge, is unconstitutional. I haven't done that yet. I think I can get it dismissed just based here. And then I'll do the constitutionality of the law itself later. But I think this is what I can win on. Maybe I will just go ahead and file it and we'll do all three motions. You know what? I'm just going to do that. I'm just going to go ahead and file it as unconstitutional. I'll just do an amendment to this. All right. That is my, my video. Wow. 1 hour. I really appreciate everybody tuning in. Please like, share, and subscribe to my channel. I want you to know that not only am I mean, I'm pretty forceful in defending my rights, but I'm also very forceful in defending your rights. And what I'm doing right here on my behalf is really what I'm going to be doing on anyone else's behalf. And what I do on anyone else's behalf, you can ask any of my former clients if they want to out themselves in the comments, how I've gotten their cases dismissed, how I've won their cases. I am very, very adamant about protecting civil rights. And I am a First and Second Amendment attorney, first and foremost. And I'm a criminal defense, or what I call innocent defense, second. That's what I do second. I want to protect liberty. I spent 21 years in the military. That oath to me meant something. I don't care what your beliefs are in the military. With that oath that I took meant something to me. And I didn't fight for my rights. I fought for everyone else's rights. I fought to defend them. And that's why when I retired from the military and decided to become an attorney, it was to continue my defense of those rights in the courtroom. So that's what I'm going to do. That's what I'm going to continue to do. And yes, I'm only licensed in the state of Texas. I do have a pro hoc vice case in New Mexico where I am suing the governor of New Mexico for her gun control in Albuquerque. That case is on hold right now, pending some appeals, so I'm not really doing much with it. And that's it. So how long have I been doing this? Angry Vet says, how long have you been doing this? I've only been an attorney. I graduated law school in 2022. I started assisting with drafting and doing law clerk type stuff during my third year of law school. So from 2021 to 2022, after I graduated law school, I got a law school graduate license to be able to practice under a supervising attorney. And I did that until November, because when you pass the bar, after you pass the bar, which I passed on my first go, 30 days after that, your license is no longer valid because you're supposed to get a real license, which I ended up getting finally approved for in May of last year. So I've been a solo licensed attorney since May of last year, but I was also a special agent in the Army, and I worked on national security crimes, investigating national security crimes like sedition, treason, sabotage, espionage, terrorism, etc. So there's that. All right, CJ, don't let the bastards wear you down. I never will. Never will. Can you help protect my liberties? Ex-military here too, CJ, longtime follower. Thank you, sir. I protect everyone's liberties to the best of my ability, but I focus again on First and Second Amendment rights. I try to be an expert on that. That's what I want to be an expert on. So I stick to those two issues because, for example, I wanted to do employment law as well, but there's just so much that goes into it. But I do employment law as it relates to the First Amendment. So, but I don't do other employment law rights issues like harassment or discrimination, sexual discrimination, stuff like that. I'm not going to do those. I'm sticking to First and Second Amendment stuff. All right, let me see if there's any other questions before I let you guys go. I don't know what John James is talking about. Hey, just took away your Second Amendment rights. No one has taken away my Second Amendment rights. I've got my gun right here on my side. I've also got 2 guns that are strategically hidden in my office that only I know where they are. So I've got my Second Amendment right. Harvey Freebird, what's up, man? He's not lying. That's right. So I defend people. I don't care if it's a Class C misdemeanor. If it's a Class C misdemeanor, I treat it like a felony. If it's a Class B misdemeanor, I treat it like a felony. If it's a Class A misdemeanor, I treat it like a felony. If it's a felony, I treat it like a capital murder case. They're all important to me because they're all trying to take your money or your freedom. Let's see. Had an attorney who worked against me and fired him, then got 2 more attorneys and they lied in court. Look, if you've got a bad attorney, even if it's me, if you've got a bad attorney who is not doing his ethical duty, who is violating his ethical duty to defend you as your representative, as an officer of the court, is lying to the court, whatever, and you've got concrete evidence of that, if an attorney steals money from you, or charges you more than is ethically necessary, or charges you all your money, does nothing, and then withdraws from the case because he's already used up all your money, report those people to the bar. We do not need. I became an attorney because there are too many bad attorneys, and the only way we're going to get rid of them is by reporting them to the bar and getting their license removed. And that's probably what Chief Blanchard is trying to do to me right now with this whole case. My town retaliated against me for my free speech and enforced codes against me, and I cited the ADA and FHA protections, and the town is continuing to retaliate, threaten, coerce, interfere with my rights. Yep, that's what it sounds like. All right, guys, I'm going to let y'all go. I want to go home. Actually, I've got one more motion I need to file in another case before I go home. I still got an hour and a half. I'm still trying to catch up from trial this week. I will say that I just finished my first. I've been to trial 3 times, but the first 2 times they were dismissed when I showed up for jury selection. And this last one I just won after a 2-day trial. I just got my first jury verdict of not guilty. I'm so excited. It feels good. It feels good to have a not guilty verdict. All right, folks, you guys take care. Be safe. Be free. I will talk to you later.